Mr. Engelbrecht is. I'll phone him now and find out why he's not yet joined. I don't see him unless I'm missing him. But I'll phone him. Oh, there he is. Rather late than never. There we go. Okay, so...
Madam Chair, in defense of your committee colleague, he's 3 minutes earlier. He's not late.
Oh, okay, well, cutting it fine, but nevertheless. Okay, so thank you, everybody. We all received the presentation. Thank you so much for that. And I'm sure that we've all looked through it, but I would invite Justice Cameron and his colleagues to present it in whichever way they see fit. And this is a workshop, not a committee meeting. So it's meant to be interactive, and we're hoping to participate fully in it. So discussion points, I think, is it okay, Justice Cameron, if we make the arrangement that as you go, when members have a point that they want to discuss in more detail or an issue to raise, can we raise hands and interrupt, or would you prefer us to do it section by section?
Please, at all times, Madam Chair.
Okay, great. Thank you. And so members, please feel free to participate fully. This is a workshop we've been looking forward to for some time. And I'm very pleased and grateful that we've finally got it on the program. And I thank our committee chairperson for his assistance in getting that done. Yeah, I think we all know what we want to achieve from this workshop. We need to compile a document from this workshop. I think that we then as a committee can promote to take JICS forward in the most effective fashion and make JICS as effective as it can be. It's being, in my view, an extremely important part of the Department of Correctional Services and play an important role. And so we need to make it more effective. We all know what the shortcomings are. We all know of the desire and need to make JICS an independent body. And so I think what we all hope to come out of this workshop is a document that we as a committee can use to move those goals forward. So with that, please, Justice Cameron and your team continue, and I'll keep an eye on the hands. And please, if I miss a hand and somebody else spots it, just draw our attention to it so that we can deal with issues as we go along. Thank you.
Many thanks, Madam Chair. We also repeat your thanks to your committee chair, Honourable Mr. Bululani Gratitude Magwanishe. For us, this is a big deal. We're very grateful to the committee, and we're going to use our time with great respect and care. We want to get through our presentation as soon as possible for two reasons. The one is the reason you've mentioned, Madam, which is that you've already got sight of it, your committee members, both of my opening remarks and of our presentation, which is on the screen. The second is that we really want to get down to the hard business of debate. Madam Chair, we're going to start with a quick update from my colleague, the CEO, Mr. Vic Missa, and our head of legal, Ms. Thembelihle Ngema and Hlanzi, and they're going to give the committee a very quick update on where we are with the Sonke extension. The guillotine is hanging above our heads at midnight on the 3rd of December, but we've taken constructive steps. We are optimistic, and Mr. Missa and Ms. Ngema will fill us in now.
Good morning, Honourable Judge, Honourable Chairperson and the sitting chairperson for this workshop, Honourable members and colleagues on the platform. We greet you on behalf of JICS, our Judicial Inspectorate for Correctional Services. Yes, I think the inspecting judge has already indicated the presence of some of our senior managers on the platform and to engage further with regards to the committee, specifically on the subject matters. I'm going to give a quick overview and ably assisted by Madam Ngema with the latest updates on what we would call the JICS independence and the application for the Sonke Agenda Justice judgment. So as we look at it now, on the 14th of October, Minister Lamola had approached the Constitutional Court seeking an extension for the Sonke deadline. And all of us know this deadline is on the 2nd of December.
Chairperson, my apology, with due respect.
Yes, please.
Can I talk to you, Chair? Before we start with, can I raise something?
Please do.
Yes, thank you, Chair. Thank you very much. And good morning, Judge and the team, and good morning, members. And also congratulations to our chair of the meeting that Honorable Breitenbach is going to lead us on this one. And because they worked so hard for us to be here. We just want to thank you very much. Before I get to the issue, Chair, I wanted to engage the committee on the documents that we have received, particularly the one that I read of Judge Cameron giving us an outline, introduction on the issue and the workshop. I wanted to raise the issue of the shape maybe that this workshop is going to take. I want to comment on that one, particularly based on the introduction that we have been given by Honorable Judge Cameron. Chair, I like what you said, Chair, that this workshop is very important and is going to give us a cue in terms of making sure that we motivate and make sure that JICS becomes independent. But and also Chair, the chair of the committee promised us that when we come here, we must just be open and discuss each and every issue in a manner that it's not going to remind us that we are in our portfolio committee. I wanted to raise those issues. But Chair, let me go back to the issue that made me to raise my hand. It is when I was reading from the introduction of Judge Cameron, I want to caution, or I want to say, Chair, I will be worried if this workshop can give me a sense of what I have read or what I picked up from his introduction presentation. Because to me, Chair, I want this workshop indeed to be what it is for, which is we're going to discuss issues in fairness and in a manner that will help us to go forward and get a solution on the problems that we have in the department, particularly facing JICS. I want to say, Chair, when I was reading from that introduction, few things that I've picked up. Number one, it is a name calling. The issue of raising or blame mode that I picked up in terms of saying we are where we are because of so and so and this and that. Chair, I want to caution on that. The reason why, because Chair, we are in a mode of elections, and I don't want this committee or members of this committee to be blamed saying we used this workshop campaigning in a manner of, even though it's not like that. I know it's not like that. I don't think that the presentation had bad intentions. It was just to highlight issues from the perspective that Judge Cameron was coming from. So my issue, Chair, is that let's make sure that this workshop, we get the research, the research that the department might have gone through and got issues locally and internationally in terms of the problems of the crisis that we are facing in our prisoners. I would request, Chair, that we should not take a cue that will make us, when we get out of this workshop, feeling or being blamed that we were here to attack or to smear anybody or any view that might be outside there with issues that we are facing in terms of the problems of this country. And also we want this workshop to give us exactly where is the problem originated. We should not, the presentations should not give the feeling that we are in a portfolio committee. I want to emphasize that. Thank you, Chair.
Thank you, Honourable Maseko Jeli, for that input. Certainly, we'll. I'm quite sure that that is the manner that we're going to tackle this thing in, bearing in mind that the portfolio committee is not partisan. So we're not here to advance anyone's narrow political interests. And I don't think any of us would follow that course. And this is a workshop for the portfolio committee, and the people here are all involved in taking this matter forward. So I think we can all do so in a mature and adult fashion and we need to grapple with the issues. And however uncomfortable those issues may be, we need to grapple with them and find a way of going forward. And I'm quite sure that all of us will approach this in that manner. And so I thank you for your very valuable input. Thank you. Would you please proceed, Justice Cameron?
May I also, Madam Chair, thank the Honourable Maseko Jeli for her observations. They are taken to heart. And may I also say that the name calling that appears in my outline, and I'm happy to be called out on that by your Honourable Member, relates to unanimous decisions that the predecessors of this committee took. And may I also say, Madam Chair, that those decisions were taken at a time when the United States had embarked on a path of mass incarceration, which they've now renounced. They've had the debate in the US. Even President Trump signed an act called the Second Chances Act, and a very important act which reversed the approach to carceral policy and penology of 25 years ago. So your remarks are taken deeply to heart. We are here in humility, and we want to, the reason I mentioned Advocate Johnny de Lange's unanimous decisions by the predecessor of this committee in the first Parliament of the Democratic South Africa was so that we could understand where we come from and where we're going. And I take the caution expressed by your member deeply to heart. Madam, thank you. Having said that, Madam, may we revert to Ms. Ngema's and Mr. Mrs. update to the committee on where we are on the litigation, and I will add a hopeful footnote to what Mr. Missa is saying. Thank you.
Please do. Thank you.
Well, thank you, IJ. Thank you, Honourable Chair, Honourable Sitting Chair, and Honourable members, colleagues. Yes, I think my part of it is just to brief the committee or the workshop on progress that has been made and put you up to speed with regards to where we are with the Sonke deadline and how far we have come with regards to the JICS independence. So the Minister has already made this application to the Constitutional Court on the 14th of October, seeking an extension up to including the 2nd of December 2023. That's giving him an additional 12 months to ensure that JICS independence is then insulated and finalized within that time frame, taking into consideration the invalidity of Section 88 read with 91 of the Correctional Services Act. Now, Honourable Sitting Chair, Honourable members, JICS filed an affidavit in support of the Minister's application that has already been shared and already been filed and also received by all parties to this matter. And in support of the application, JICS funding model and organizational form is actually yet to be approved by the Minister of Finance. Now, just a little bit on this. The IAC, which is an interdepartmental assessment committee, was established. They determined and made recommendations that JICS should be constituted as a national government component. And the two issues that were outstanding was the sign-off from Treasury ensuring the additional funding, what we'd call a top-up to its existing budget, to ensure that JICS is then separated from that of the Department of Correctional Services, and identifying the CEO and appointing the CEO as the accounting officer of JICS. So proposals have been made, standalone proposals have been made specifically to the Correctional Services Amendment Bill. I think you've seen that. But this actually was extensively debated between the inspecting judge, JICS representatives, Minister Lamola, and also Deputy Minister Holomisa was part of these discussions. And we found that the Correctional Services Amendment Bill was not exhaustive enough and did not cure specifically the defects of Section 91 dealing with the appointment of the CEO, which still remained with the DCS, the National Commissioner, as being the accounting officer of JICS. So maybe just to indicate other parties and that are part of this and that has already actioned the status in this matter. Sonke itself has already filed a notice, and that has been shared, that they would abide with the court's decision, whichever way the court decides. They've already filed this, and we've already received this, and it's already tabled. Before the Speaker of Parliament, I think our Honourable Chair has already submitted also a affidavit in support of the extension, and also supported by the Speaker of Parliament for that application so made by our Honourable Chair on behalf of this portfolio committee, this esteemed portfolio committee. May I add that based on that application by our Honourable Minister Lamola, which has also been filed and extensively shared amongst all, we have not received yet a filing or papers from the Minister of Finance. Now, once again, Honourable Sitting Chair and Honourable Members, the two areas that we need confirmation on is National Treasury to confirm the adoption and establishment as JICS as a national government component, and secondly, to confirm the funding that is required as a top-up. Its current budget is 80 million, Honourable Sitting Chair, Honourable Members. It is actually less than the Paulsmoor kitchen budget, as we always say. It's less than the Polokwane's whole prison budget, versus a budget allocation of almost 25 billion rand allocated to the department. So this is the hurdles that we face. So we are just awaiting what we would call filing of papers by the Minister of Finance, which would then give the Constitutional Court the opportunity to evaluate those papers and determine the way forward. So all we wait for is Constitutional Court's directive, the amendments to the Correctional Services Act, and the finalization of the JICS bill, version 20, which is already in your inboxes, is pending the National Treasury's approval on the outcome of the extension and the application. Honourable Sitting Chair, Honourable Chairperson of the committee, members, IJ, I would humbly request Madam Ngema, with the latest engagements of this morning with National Treasury and councils in the matter on behalf of the Minister of Finance on her updates. Thank you.
Thank you, CEO. Greetings to the chairperson, the honorable members on the platform, and the colleagues from JICS, IJ, CEO, and other colleagues. Good morning. I would like first to confirm what the CEO has presented. It is true, and this morning I had a conversation with the attorney who's representing the Minister of Finance in the matter, and she assured me that she has not received any instructions to file any papers in respect of this matter. So it will seem that the National Treasury is not going to be filing anything in the pending pending matter in the Constitutional Court. That is all that I would like to add to what the CEO has said. Thank you very much.
Okay, thank
Madam Chair, I'm very grateful to my colleagues. May I go back to Ms. Maseko Jele and tender an apology. I think I know more clearly now what she's referring to. I want to ask the committee to treat my paragraphs 9, 10, and 11 as pro non scripto, Madam Chair. And Madam Maseko Jele, my apologies to you. I know what you mean. And I'm just going to stick with history. And may I proceed on that basis with my apology recorded by the committee, Madam Chair?
so recorded, Justice Cameron. I think we all understand the reason for them being inserted, and no offence is taken. We'll deal with it on the manner that you request. No problem.
Thank you, ma'am. Can I start by saying, Madam Chair, that we are in a crisis of crime. We all are affected by it. When I speak to groups of people, whether they Soweto school kids or people in the northern suburbs of Johannesburg or the rural areas, I say, who's been affected by violent crime? A sea of hands goes up. I say, who's been affected by violent crime in their homes? A smaller sea of hands goes up. So that's the basic premise. And my historical comments are two, and I try to keep them neutral, which is that we, together with the United States and the Tony Blair government in the 1990s, embarked on a wrong concept, which is that long sentences are going to help us reduce crime. Madam Chair, I want to state from my heart and from my stomach, long sentences do not deter crime. What does deter crime is the certainty of follow-up, of detection, prevention, arraignment, arrest, appearance in court, and consequences. Often there have to be severe consequences, often life sentences, sometimes life sentences without parole. That is our common ground. But what went wrong, Madam Chair, in our presentation, we've got some staggering graphs, which I think most of this committee are familiar with. The committee of 1990 was operating on a wrong premise, the panic premise that we had a massive crime wave, whereas in fact, if you look at that graph, from 1995, the murder rate fell until 2011. What happened in 2011, without finger pointing, rightly rebuked by your member, Madam Chair, without naming names, is that crime intelligence became dysfunctional. And that's where we've got to start. There was a huge increase in crime. Why is crime intelligence so central, Madam Chair? Because it's so simple. You take a budget, and if you have an honest administrator, you find out who in every suburb, rural area, or township is organizing the cash and transit heist, who is organizing the attacks on non-national truck drivers, who's organizing the copper cable thefts, who's organizing the Zamazamas. We had a parade on television of the Zamazama kingpins who were captured with nice vehicles in Carltonville. Alas, Madam Chair, they were not the kingpins. They were the middle managers, even the lower middle managers, the kingpins with an effective crime intelligence system. So, Madam Chair, for me to come and say to this committee, start fixing crime intelligence is no good, because that is the function of other committees. It's a long, slow process, but it can be done. There's nothing in our country, Madam Chair, there's nothing, not corruption, not crime, not our terribly high murder rate, that cannot be fixed by us starting now. But in that atmosphere of humility and urgency, Madam Chair, we can proceed to the next slide, where we urge that selective crime responsiveness plus long sentences is not only pointless, it's damaging, it's expensive. Look at that graph. It's a staggering graph, Madam Chair. We have 24,000 murders in the latest police figures released by General Cele. How many convictions in the same year? barely 11%. So it's a horrible thing to say about rape and murder, but over 80% of rapists and murderers go off scot-free. So we responded wrongly. I'm emphatic, if you look at paragraph 18 of my presentation, that there are evil, violent people. Some of them must be locked away forever. Some of them must be locked away for very long. But more important is that we have a functioning crime intelligence, crime response, detective, and administration of justice service. We can proceed to the next slide, please. So what do we suggest to your committee, given that long sentences on their own, and this I'm speaking with criminological and penological authority, there are very few things that we know about crime. The one is that we know that the death penalty doesn't help. If it did help, we'd have a new debate about the death penalty. If it inhibited murders, let's think about whether we should have it, horrible as it is. I was involved with the death penalty with the Sharpeville Six. I was involved with clients who got hanged in the 1980s. I'm an opponent of the death penalty, but at least we could have a good debate. But we know from the stats over the last 150 years that it doesn't change anything. The same is true of overlong sentences. So what do we suggest? We suggest, if we go, and I can actually finish quite quickly, Madam Chair. If you look at paragraph 46 of my presentation, my first step is that I say this committee had before it the recommendation of the South African Law Reform Committee. In fact, it referred issues as a matter of history without finger pointing, Madam Jele, Honorable Madam Jele, without finger pointing, it referred the matter to the SAHRC and then in a panic said respectfully, it enacted these long sentences without waiting for the recommendations. The central recommendation, 2000, 1 year after the long sentences, was have a sentencing council that looks at areas, looks at crimes, looks at manner of perpetration, determines sentencing guidelines, not mandatory minimums. And there's one figure I want to give you going back to paragraph 20. We've got life sentences for rape, life sentences for murder. In 1995, at the dawn of our democratic dispensation, how many people serving sentences of life? 443. Today, as we sit here this morning, how many are serving life sentences in our jails? Nearly 18,000. I want to add to that one fact. 2 weeks ago, we had a highly successful regional and African seminar on judicial oversight of prisons. Let me give you Malawi. Malawi has got 80 million people, about a third as many as we have. They've got 15,000 prisoners. You'd expect comparatively that we would have 45,000 prisoners. No, we've got 3 times that. And that figure, Minister Lamola asked me to substantiate that figure. We're sending his office very shortly an Africa-wide graph which shows that South Africa grotesquely, disproportionately, Madam Chair, incarcerates people, over-incarcerates, sentence inflation, life sentences, much more than any of our neighbors, Namibia, Zimbabwe, Botswana, Zambia, going up to Nigeria. We had Nigerians there. We know that violent crime was a problem in Nigeria, and they have a fraction of the number of life sentences and persons in prison as we do. 150,000 people in prison, the biggest number on the African continent, the 12th highest. We're only 11 places behind the United States, which invented this horror of mass incarceration of mainly Black people. So, Madam Chair, can we go on to the other slides? Because I really want to wrap up now. We've got other issues that we want to mention, Madam Chair. Solitary confinement, non-nationals, remands and overcrowding, DCS violations, and women in prison. And I want to invite my colleagues to take questions as well, but let us go through those. My pitch to you, Madam Chair, is at the end of my presentation. It's in paragraph 46. We know this committee cannot sole-handedly rebuild the justice system. We know this committee cannot single-handedly rebuild crime intelligence to find out who the real kings of the Zamazamas are, kingpins are. But what the committee can do is three things, and they're in paragraph 46. Go back to the Sentencing Council, reinstate the Sentencing Council. It's all there in practical terms, in sensible practical terms, in the SHRC report of 22 years ago. Once you've done that, and we've had the public debate, which they have had in America and we haven't had here yet, then this committee will have a platform and a premise to scrap all outdated crimes, like sex work. Deputy Minister John Jeffrey is championing that. It's gone through cabinet rightly, but there are other worthless crimes that we can scrap. Madam Chair, countries are increasingly moving in South and Central America. Portugal has already done it. Scrap drug offenses. It sounds radical. Well, how radical is former President Kgalema Motlanthe? He's not a radical. He's one of our most respected former presidents, again, without pointing fingers, but he's a person of great substance and sobriety. He has signed the International Global Initiative on Drugs, signed their statement to say, move away from criminalization, treat it as a public health issue. We had prohibition of alcohol products. It was a calamity in the United States. Prohibition on drug products is also a calamity. It is a public health issue, and we should regulate severely. We should have strong messages. That will start diminishing the terrible mayhem that is happening very close to where your committee is sitting, in the Cape Flats townships, in Langa, Khayelitsha. And then we urge the committee, thirdly, to focus then on crime intelligence, detective services, and effective on-the-ground policing. That's my pitch, Madam Chair. We've taken less than half an hour for two of our main points. If I may go then to solitary confinement. CEO Missa, is it our plan that I should quickly take the committee through this? Is there anyone else who can come in? I invite colleagues to do so, but my colleagues are all available for questions and responsiveness. Madam Chair, we sent your committee in January this year our report on solitary confinement at Ebongweni, at Pretoria CMAX, and in a different form at Mangaung Max, the private prison run by G4S. We say, Madam Chair, and here again we are substantiated by international research, by on-the-ground experience, we say that solitary confinement is being perpetrated against the statute in our prisons. We say that it's wrong. We were there with Minister Lamola. We are making constructive inputs to DCS, to the department, on how they can ameliorate it. We're saying to them, go away from solitary confinement, give the inmates more access, reconsider the current 3-year behavior modification, allow meals to be eaten out of cells, give more books, give more visits. What is happening is in conflict with our constitution that speaks of conditions in accordance with dignity. Solitary confinement is destructive of dignity. CEO Missa, Madam Ngema, our legal head, Madam Sabuta, you presented these slides to Minister Lamola, to incoming National Commissioner Tobakale, and if you have anything to add, please do so, colleagues. Madam Chair, if I may move on to non-nationals, we've got a constructive agenda for this committee on solitary confinement as well. We're asking you to release that report. We're asking you to exercise your oversight on DCS about the practice of solitary confinement, and we're asking you to legislate a ban on solitary. On non-nationals, Madam Chair, again, we've got a practical agenda, and the practical agenda springs from a practical problem. there are non-nationals who've reached their release dates. They're non-nationals who are entitled to parole. They're still in our prisons. Why is that? Because Home Affairs, to put it bluntly, and I don't want to retract my apology to your honourable member for naming names, but Home Affairs hasn't got its act together. So what do we ask? We ask you to summon Home Affairs to Parliament, because those people shouldn't be in the correctional system. Home Affairs should be dealing efficiently with them, Madam Chair. And then we go to our next point, which is remand detainees. Madam Chair, 2 weeks ago, with our SADC colleagues, the workshop was co-hosted by my colleagues, Supreme Court Justice Namibia Mainga, Sylvester Mainga, Justice Keenan Manda from Malawi. We were the 3 co-hosts. The figures, the stats from the entire SADC region, Madam, from Nigeria and other countries which attended, like Tanzania, those stats show that our remandees are very, very gravely, and this committee can do something about it. Look at those figures in that slide. We've got 1/3 of our total population are remand detainees. It's a grievous heartache, Madam Chair, and we can deal with that now. Those who are under 1,000 rand bail. We were told recently that there are people in Sun City, Johannesburg Correctional Centre, who can't afford bail of 300, who are sitting in jail. That can be remedied by this committee by intervening. These are prisoners of poverty. Our concerns are excessive detention without being processed in the justice system, many accused of petty offences, poor conditions. What do we ask you to do about overcrowding and non-nationals? Look there, the lockup is 41,000 over capacity. We highlight the risks, Madam Chair, and I don't spell them out because everyone on this committee, you share JICS's concerns. We know that, and you put a youngster in awaiting trial detention to learn the tricks of criminality and to be exposed to disease. So what do we ask, Madam Chair, if we can go to the next slide? We urge that this committee legislate alternatives to cash bail. We at JICS are also doing something about cash bail, which, let me just drop in a quick footnote here, if I may, Madam Chair. Bail fund. It's a contested idea in America. You raise money from public interest sources, and you pay the bail on certain conditions of people. This is outside the justice system, outside the department. It's an apparatus that offers bail on condition to people, and that can help considerably. So JICS is doing something about that outside this committee's remit. But we ask for sound alternatives to cash bail. We ask for this committee to use its oversight for the use of Section 63A. You distributed 2 oversight reports to us, Madam Chair, in the last few days. I think they came from Mr. Sia Ntongeni. And I know that this committee knows about those legislative interventions because they went to all those prisons, both in March and more recently, and they asked the prison heads about it. We should follow up on that. And then there should be more special release programs for non-violent, low-risk inmates, and there should be legislated non-custodial offences where appropriate. This calls for collaboration between Parliament, DCS, and the judiciary. Another issue that I know troubles this committee, and the committee knows about this, Madam Chair, brandvlei. Dogs are set upon to inmates under the eye of cameras. The inmates are taken out, torn to bits, they die. 7 years later, there's still no prosecutions. We're onto it with Deputy NDPP Rodney de Kock SC. We're onto it, but we think that the accountability, this is not a finger-pointing exercise. Again, with humility, we go back to the reminder by your honorable member. Let me tell you why it's not finger pointing, because this is a problem in all systems of carceral systems. Wherever you've got prisons, there's a tendency to close ranks, to not offer defense. The first police officer convicted in decades for the killing of another person who was the black man in Chauvin, Derek Chauvin. He was the first convict in decades. So not finger pointing. Wherever you have police misconduct, carceral officials misconduct, there is a tendency not to offer evidence. And we point to the lack of cooperation from DCS officials who are implicated in unlawful conduct, lack of cooperation from SAPS, which doesn't provide dockets. And we are also doing active things here, Madam Chair. We in conversation, we hope to get a meeting with Deputy NDPP Rodney de Kock in December, because we want a memorandum of understanding. We know that Advocate de Kock has got reservations about that for practical operational reasons, which we respect, but we want more fire in the case. If you convict one or two DCS officials who have been proven beyond reasonable doubt to be guilty of gross violations, then we believe that the whole system will improve. And then we ask this committee to direct us all to get our acts in order. That's the third last point on what is being displayed. And then the Phoenix investigation. We did a very careful investigation. We are at odds here with the department, Madam Chair. CEO Vic Missa, do you want to come in here and give a few short updates on the Phoenix investigation? Am I putting you on the spot, Mr. Missa?
No, not at all, not at all, RJ. You're most welcome. Sitting Chair, honorable members, and our chairperson of this honorable esteemed committee. Yes, I think we've concluded what we would call out of the July unrest of 2021, where 64 inmates were incarcerated at the Durban Westville prison, and they were treated somewhat indifferently during the course of that incarceration, pending their appearance in court. We finalized the report. We've exchanged the report with the National Commissioner and representations from DCS. We have not come to commonality on the finalization of some of the areas within that report. We still await the National Commissioner to get back to us in order for us to finalize the report. But that's not the only issue. The issue is now we have been pressurized by family members of that community now to release our report, and we are also sitting with what we would call a PAIA application to release this report. Now, we have taken a decision strongly to deny the application, pending the finalization of the discussion with the National Commissioner, and most importantly, tabling this report with this esteemed committee in order to get direction and way forward from the committee on this specific report. The report is termed indifference or indifferent treatment during the incarceration of those 64 inmates at the Durban Westville prison. We are awaiting finalization of discussions with the National Commissioner, as I alluded to, and as soon as we have concluded this discussion, sitting chair, honorable members, we would then make this report available to this esteemed committee. Thank you, Ajay.
Many thanks, Mr. Missa. I'm grateful to you, and I'm grateful also to the committee. We'll momentarily. Madam Chair, we have given the committee a laundry list of practical interventions. The last one we come to in overview is incarcerated women. We're glad to say that the Honourable Speaker of your House, Mapisa Ngakula, recently raised this issue. We're not doing badly, interestingly, Madam Chair. Across the world, the World Prison Brief shows that the number of women in prison has been going up. We've remained stable. We've around about 4,000 women and girls, under 10% well, far under 10%, a fraction of 10% of the 150,000 detainees, 65 infants with their mothers. But Madam Chair, we say that the position of women is still not acceptable. We refer to the fact of the Speaker of this House, who recognized that many women have been incarcerated for responding to or defending themselves against gender-based violence. We advocate for an independent assessment, not a long, structured, platformed, committed, but a retired judge who can independently, for instance, assess each case of the women who say that they were responding to gender-based violence. So Madam Chair, the women as outliers experience all the same challenges that males do, but in addition, they have particular problems, including lack of appropriate hygiene products and healthcare. We're dealing right now with a particularly tragic case of women in Johannesburg Central. I won't name her name, but we have succeeded in helping her get swift gynecological and oncological treatment for cervical cancer. The tragedy, Madam Chair, is that this should have been diagnosed much earlier. And as your members know, cervical cancer early diagnosis is one of the easiest cancer forms to treat when you diagnose it properly and treatment is available. There's a tragedy that hers has progressed, but we believe that with the outstanding radiological treatment she is now getting since the 7th, since this week, that her condition will improve. And I mention that only because it is emblematic of the plight of women in prisons. So, Madam Chair, I believe that brings us to the last of our laundry list. We wanted to complete within an hour, and we have done so in order to leave a space for your committee to discuss and to debate and to go off and reflect on what we've asked it to do. We ask you to call in the department to account for the singular position of women. Again, we've asked you to reconsider the criminalization of drug use, which has been as the most catastrophic public policy mistake since Richard Nixon on the 6th of June, 1971. Again, history, Madam Chair. The most catastrophic public policy mistake has been the war on drugs. It has wrecked the criminal justice systems of South and Central America and of the United States itself. And it is threatening to wreck our criminal justice system as well. There are better, more effective, more just approaches, which is to say drugs are evil, like alcohol and smoking, and treat them as co-equivalent, adaptedly equivalent public health issues. And sex work, really, Madam Chair, with deep respect, decriminalize it yesterday or the day before yesterday. Social services and welfare for mothers, the National Strategic Action Plan on GBV and femicide should be implemented in prisons. And then we ask for accounting to this committee by the department for the Bangkok rules in relation to women. Madam Chair, this has been a privilege. We know what a rare privilege it is. We thank you from our hearts. We look forward to being challenged, to being scrutinized, and to assisting the committee where appropriate to draw up a practical list of interventions that the committee considers feasible for it. Thank you, Madam Chair.
Thank you very much, Justice Cameron, and your team. That was a very concise and directed presentation, for which we are very grateful. I would like to invite the members on the platform to engage with you. Again, as mentioned by myself and the Honourable Secretary, not in the form of a committee question and answer session. I would like us to debate these issues. We have the time, which is very, very rare, as you say. I'm grateful to our chairperson, the Honourable Magwanishe, for allowing us this whole day to deal with this matter. And we have the time. Let's debate these issues. so that the members can crystallize in their minds those issues which we can take forward. Forgive me, I have no control over my dollars whatsoever. So that we can crystallize in our minds the issues that we can deal with immediately and that need to be dealt with immediately. Those issues that we can deal with in a medium term and those issues that we deal with in a longer term, but hopefully still in the term of this sixth parliament. So I thank you for the presentation and I invite members to engage with you. I have many points that I would like to engage on, but I'll give everybody else first the opportunity so there's no duplication. So everybody who wants to engage, please do so. There is a speaking order at the moment, but again, I would like to encourage you, if during the debating of the point between one member and the JICS members, there's something that you want to add to that point, feel free to interrupt. You don't have to wait for your speaking turn. We'll start with the Honourable Magwanishe. Thank you.
Well, thank you very much, Chair, Madam Chair. And thank you and Judge Cameron for organizing this workshop. We know that you have both yourselves, Honorable Janji and Judge Cameron, being involved for the logistical arrangements of this workshop. For that, we thank you. I've got just a few points to raise. I think the first one, if you look at the presentation, which we are grateful for from Judge Cameron, I think it's very educational. The drop in murder cases from 94 to 2011, starting from 2011, then they shot up. I think it's important also to look at this in relation to the parts that started, especially for the criminal justice system, because I do think that there is also a fallacy of thinking that you can build a strong economy when you are not investing appropriately in your criminal justice system. I think it's a big fallacy. And as a result of that, the point that Judge Cameron has raised about crime intelligence, there are also, notwithstanding the issues that he has raised, but there are also issues in relation to aging technology that has not been, in fact, we have not invested properly in the infrastructure. And as a result, it's very difficult to even to do surveillance to criminals who are using modern technology, 5G technologies. So it's critically important that there must be serious investment on a crime justice cluster, be it intelligence, be it prosecution, be it police. But it's very important because with that, then you will be having the certainty that Judge Cameron was talking about, that what will be a strong deterrent to crime will be a certainty that you would know that you will be arrested and you'll be prosecuted and you'll go to jail rather than long sentences. I think that is one of the issues that we need to look at. And the other issue, I think it's the, with respect to the introductory remarks that he has made, is generally an understanding and respect of the Constitutional Court judgments by the whole of government. Because I think what we are seeing now, it's one department that is so engraved in its own processes that it doesn't matter whether there is a court judgment or not, whether there is a court deadline or not, but we are so in love with our own processes that those processes have no bearing in us. And I do think that that kind of an attitude is going to undermine our constitutional democracy. There is a reason why we have chosen the supremacy of the Constitution over the supremacy of Parliament. And it is expected that all South Africans, organs of state, and everybody would respect that constitutional democracy, that constitutional supremacy. Now, the fact that we are not even sure now what the response of National Treasury is going to be, for me, is highly problematic. It's problematic for me that we have to spend monies on lawyers going to court for an extension for something that could have been discussed in the last 2 years and finalized by both National Treasury and the Department of Justice and JICS. So I think it's very for me it's very worrying, that kind of an attitude. Because I also think that it's an attitude that does not take into account the proper functioning of the whole of governance. That is why now you have a situation where criminals are having more advanced technologies than the law enforcement agencies. I think the summary, Chair, that you have given us, I think it's what I was going to also dwell on, that we have to identify issues for immediate, medium, and long term, because one of the challenges that I think we have to seriously think about, even in the short term, to deal with, is a situation where this discussion does not end here with us. This discussion must be made to engage the whole of society, because we have an information asymmetry where you find that certain pockets, like in this case, the JICS, will have more information than other people. Even in certain instances, the lawmakers, you will find that sometimes general members of the population, they believe that our prisons are 5-star hotels, whereas we know that that is not the case. I think it's important that there should be this discussion, even the effectiveness and the efficacy of your minimum sentences, not only being discussed by us alone and thinking that we are going to just quickly change laws, but engaging society as a whole about the need to have a mind shift, and taking them into our confidence as to these are the trends nationally, these are the trends internationally, and this is what we need to do to ensure that we achieve that mind shift in how we view custodial sentences, because there's still, even amongst lawmakers, people who view long sentences as the answer to the issues of crime. Now, I would suggest, Chairperson, that maybe with the assistance of Judge Cameron, we have this bigger workshop that is going to ensure that society, judiciary, everybody is part of that a move, because you can have a situation where we pass a law like it happens with GBV when everybody was marching to Parliament. Then because of that, then you are reacting to a pressure. So we must avoid that and make sure that we take society with us in ensuring that there is a mindset that is shifting towards a new approach. Thank you very much.
Thank you very much, Honorable Magonisha. Is there anybody on the platform who wants to add to those points before we move on?
Apology, Chair.
Yeah, Honorable Maseko Jele, go ahead.
I'm still struggling to raise my hands here. Thank you very much, Chair. And thank you also to Judge Cameron for the presentation. I think Chair has covered me on the issue of issues of legislation that we should, before we can even go to that area of heavily legislating some of these things, we need to be very careful and take everybody on board, and I support that one. And another issue that I would like to add, it is the issue, Judge Cameron, of looking at the surroundings, the fact of our surroundings, which are impacting or which are the factors which are impacting on what we have now. Dealing with this issue from the point of view of only inside, it can also not help us. Maybe we must also look at the surroundings as to what are the causes around this issue that are an impact on this. And then I think, Chairperson, I'll support the view that we must have a bigger workshop where some of these departments that are also, their areas are an impact on this issue that we are dealing with today, might also come and make presentations, and we discuss these issues holistically, and we come with a solution. And also on the issue, I think the situation is bad, yes, in South Africa, but Judge Cameron has just given us a point on the issue of the listing, that South Africa, we are still under 10, but as he indicated that we are number 11 in the world with this issue. I think we must also try to look into this number 1 up to 10 as to how are they dealing with these issues, with this issue, so that we can also learn more before we can even go to the issues that maybe will require us to legislate heavily, because our rushing into the some of the solutions that we might undertake, it might also be a problem maybe in 10 to 20 years to come, and would also want to go back and revisit and say, where did we go wrong? I think it will be very much important for us to treat this issue in a manner that it will be lasting in future, because there's a lot that is really involved here. Before we can even go to the point of reinstating that committee, the council, the sentencing council, we must look into these issues, and then we reinstate, because for us to reinstate them without dealing with the real issues that are contributory factors towards this, it might even us launching that council in a way that they would want maybe to look into this issue in a manner that is like maybe the approach that we want to take now. Maybe if we can start first dealing with these issues deeper, and then later we can bring in that issues like this one of the reinstatement of this council chair, because we have to also make sure that we get JICS independent, and they will also, that issue on itself, they will assist us. But even that one also is still an issue, because it also depends, Judge Cameron, on the people that you are bringing into these committees, because we might be hurrying coming up with these committees only to find that the very people that we are bringing in are not helping us in terms of moving forward in resolving these issues. Hence, I'm saying let's deal with these issues in a very broader way, and then we come closer to the solution and we accept some of these issues. That is my contribution on this, but I'm not negative in terms of us undertaking some of the suggestions that are brought forward by the Judge Cameron and the team. Thank you very much, Chair. Sorry, my apology for that.
Thank you, Honorable Masekajene. Honorable Engelbrecht, and then Honorable Nivadraga.
Thank you.
Just check with Honorable Magwanishe, is that a new hand or an old hand?
old hands, Chair. Sorry,
Okay.
my apologies.
Okay, thank you very much, Madam Chair. I firstly would like to thank Judge Cameron and his team for availing themselves to have this engagement with us. From my perspective, I think that the Department of Correctional Services are receiving the short end of the stick, so to speak, or getting a raw deal, because the origin of these problems are, for the most part, not correctional services, but that is inevitably where all the problems ends up. I think we sit with this in parts dysfunctional criminal justice system, which then dumps their problems at correctional services, which has to deal with it. Now, I can only speak from the perspective of a facility which I visited, as well as one of the magistrates' courts that sends their remanded detainees to the Krugersdorp facility. And from my perspective, I can say, I don't know, I don't want to call it overzealous magistrates, but it's like a sausage machine, what I saw. I mean, it's case after case. Bailey's either opposed or agreed upon, Bailey's set, and the correctional facility receives inmates by the truckload, and it's never ending. The Krugersdorp Correctional Facility now stands at, I think it's, if it's not over, it's very close to 200% occupancy rate. Those conditions, they are horrible in terms of overcrowding. To add to that, you have the South African Police Service that detains undocumented immigrants, and they are also first stop dropped at the correctional facility at Krugersdorp by the truckload. And the correctional services officials cannot show them away. I mean, they have to take them, but there is no space and it never ends, and there's no remedy for them. So I think the thing that we should really investigate is to look at the entire criminal justice system and have a multi-departmental approach where we include Department of Justice, we include the Department of Home Affairs, and we include South African Police Services, where we can look at this from a much broader perspective and look at the origin of these problems. And if it is bail, we address bail, and that is a Department of Justice issue. And if it is about the undocumented immigrants, we need to have a chat with Department of Home Affairs and with the South African Police Service. Because I think from only from the perspective of correctional services, in the narrow sense of the word, we can get some stuff done, but I don't think we will effectively be able to address the problem holistically speaking. Thank you, Madam Chair.
Thank you very much for your inputs, Honourable Engelbrecht. Honourable Nieuwenhuizen.
Thank you very much, Chairperson. Thank you, Madam Chair. Good morning to everyone, and thank you to Honourable Breitenbach and Janki for arranging this workshop. And thank you for JICS for giving us the time to have this workshop. While I was reading through and preparing, I thought to myself, maybe the Justice will, JICS has brought this issue to the wrong committee. Maybe you're talking to the wrong people, I thought, you know, but and what my colleagues said, I think it's a whole cluster issue. In the presentation on slide 9, the numbers given there, the murder, which is over 24,000, but convicted is over 2,000. And then rape is 41,000, and then the conviction or the convicted is only 3,000. We must talk to the normal public, the family members of victims that we meet, that we see on TV, maybe after a conviction or no conviction was brought, or a light sentence was given. How upset the family members are, that they feel that they got off too lightly, or some are happy and satisfied with the number of years that the person got. But I think our people has a mindset of the larger the conviction, you know, the more it fits the crime. But by the time that the person gets out of the system, you know, whether they are good or bad. So I think the gap between being imprisoned or being arrested and convicted, what happens in between? Is there enough evidence? Does SAPS, you know, did they collect enough evidence? And in the end, the judge might say, sorry, you know, you are going free because there's not enough evidence. So, you know, what is really done beforehand? So that's why I said, you know, I was wondering if it's actually the correct committee, because I think this workshop should be discussed with the whole cluster, and we need to discuss all the issues that we are facing in South Africa with regards to this. Then the non-nationals, if we have a look at slide 16, where justice says, you know, we need to call Home Affairs. But now my question is, before we point at Home Affairs, in my understanding is, you know, if a person is on parole, it's only given if they have a permanent address. And parole is only given if the family members agree to accept that person back into, you know, their house or in their homes before they can be let out on parole. Now, when parole is granted, or the sentence has ended, should they then be sent straight back home? Or, you know, how I feel there's not enough debate with regards to that. And plus the overwhelming issues faced by Home Affairs themselves. So that's why I'd like to hear from the whole cluster and what they have to say about all of these things. Now, the less than 1,000 bail, you know, some of the people are so poor that they cannot afford. They do not have the means. The families don't have it. The grandparents only get pension. They cannot pay the bail. And we've had this presented in the committee previously. And I can't remember what the conclusion was, but there, you know, I've also asked an alternative, you know, if they are still in remand and awaiting sentencing, the reason, you know, that they are there, they haven't been to court, it's not given, you know, the reason why. Can it be substituted with community service? And my question is, do we have enough staff, or do we have the capacity to be able to monitor community services? I studied in America, and sometimes I forget what was there and what is here. And I did ask it previously, I think while we were discussing, I can't remember which bill it was, but, you know, an alternative, any alternative sentences, you know, do we send people directly to jail? Like, for example, you're saying the drugs, you know, drug sentencing or drug crime should be decriminalized. But if there's violent action or violent crimes because of the use of drugs, sometimes that happens. Now, what is the alternative? Instead of sending them to jail, sending them to rehab, you know, to get drug rehab treatment. But do we have the capacity? Do we have enough social workers? Do we have enough counselors? Do we have enough therapists to assist us and our criminal justice system, or the criminal justice system as a whole, with all of that. And then you talk about the bail fund, which is a very nice idea. But, you know, if we go back, who's going to administer that fund? Who's going to contribute? Where is the funds going to come from? Is it JICS? You know, who's going to add to that fund? And then what we have to discuss, what criteria needs to be given so that inmates can benefit from the bail fund, for example. I think for now, those are my comments. Thanks, Chair.
Thank you very much, Honourable Nivadracha. I have one or 2 points I'd like to raise in conjunction with the contribution made by the members, and then we can perhaps discuss them. So, of course, the budget is a perennial issue, and it needs to be addressed. We all know where we are as a country, and that money is not unlimited. So I think we need to find an innovative way of approaching the resourcing of JICS as an independent body, and we'll need to have a look at that. I'm in agreement with Justice Cameron with his views on long-term sentencing, and particularly minimum sentencing. My own experience of minimum sentences as a prosecutor was simply that the better representation you could afford, the better your chances were of producing real or not so real compelling circumstances that would mitigate the implementation of a minimum sentence. So people who couldn't afford flashy lawyers invariably received the full minimum sentence, and people who could afford expensive silks always managed to find circumstances that necessitated the imposition of a lesser sentence. I'm not a fan of minimum sentencing, and I honestly don't think they serve the purpose that they possibly were intended to serve. It is so that the population of our prisons has increased exponentially as a result, with absolutely no benefit to show. You know, once again, Einstein's definition of madness is you keep doing the same thing over and over and over again and expect a different result. We've spent years and years and years sentencing people to long-term imprisonment, and has it reduced the crime rate 1 iota? No. So we do need to be more creative, more innovative about how we deal with that, and we need to look at international best practice, and including what works in other African jurisdictions. Then overcrowding, also a perennial issue, and once again, the awaiting trial prisoners, awaiting trial detainees form a large percentage of the prison population, and they can be dealt with so easily. We have legislation in place that deals with protracted procrastination in any criminal trials, both on the part of the accused and on the part of the representatives, and sometimes also on the part of the state. And it's not effectively or efficiently implemented. And I think sometimes perhaps judicial officers are a little lenient in their application thereof. The Criminal Procedure Act does allow for matters to be struck off and punitive measures to be put in place for re-enrollment. They can refuse postponements. Traditionally, they don't do that. I'm not sure how we should address that. It's very difficult to address approaches by the bench, and perhaps Justice Cameron could help with suggestions in that regard. But I do believe that would go a long way into shortening these enormously protracted trials where almost any excuse is good enough to get a postponement. It's bordering on the ridiculous that a trial can take, and I think I hold the record for the longest trial in South African history. When I prosecuted a former senior advocate at the Pretoria Bar for 22 years. 22 years. my entire adult life, trying to get this oak into jail. Eventually he was convicted, but he got to spin it for 22 years with the most ridiculous applications, and more than often than not got away with it. I think the judiciary needs to be a whole lot more hands-on with refusing spurious applications for postponements and forcing accused to stop playing the fool with the justice system. Similarly, prosecutors must be forced, if they enroll a matter, to finalize it. And police must be forced to finalize an investigation. You can't investigate for 10 years and then bring a docket to court. It's ridiculous. There are so many prejudices for everybody involved. And so the members who have suggested that, and JICS, that it should be an industry-wide, for want of a better expression, approach is so. It's no good blaming the NPA, it's no good blaming DCS, it's no good blaming the police. It's a systemic problem in all of them, and does need to be addressed. And I would honestly support a workshop of all of those role players in order to try and address those issues. But again, it can't be done without a certain amount of changing of the approach of the judiciary to postponements. My own experience of postponements is that it can drive you to drink. The most spurious applications get granted and allow trials with the roles the way they look, allow trials to be postponed for a year at a time. And that is justice denied, in my view. So, and that just adds to the backlog in court trials, which adds to the prison population being extended and extended and extended. Awaiting trial prisoners, in my view, can be dealt with very effectively. I remember a program that we ran in the early 1980s. No, I lie. In the early 1990s in Johannesburg, where we had night courts, where prosecutors and members of the bench and the attorneys and advocates profession all volunteered their time for 3 or 4 hours after the court's official closing time to deal with such matters. Matters where accused had been in custody for a long time, so do the trials and get them done. And also to deal with people who had been in custody for a long time and couldn't pay bail, reconsider those matters, deal with them differently. It really worked. It worked exceptionally well. Nobody got paid for it. Everybody volunteered. And there can be no real reason why that couldn't be done again. I know from my own inquiries in the legal profession that the legal profession would be willing to volunteer for that kind of thing. So, you know, we need to get the other role players to come to the party and revisit this issue. I absolutely agree. Somebody who can't pay bail of 1,000 rand and remains in custody for the want of it shouldn't be in custody. 1,000 rand in today's terms is not going to force you to attend your trial. And I do think that people need a lot of education about what bail is. The general South African population increasingly seems to think that bail is connected somehow to guilt or innocence or the seriousness of the offence. And I'm not trying to lecture Justice Cameron, God forbid, on this topic, but we all know that bail is sui generis. It stands alone. It's got nothing to do with, or very little to do with guilt or innocence, very little to do with the seriousness of the offence. It's got everything to do with securing your attendance at your trial. And for me, that might be 10 rand. For somebody else, it might be 1 million rand. And for offences, if you're sitting bail of 1,000 rand, honestly, if you're not going to attend your trial, you're not going to come for 1,000 rand. You're going to pay the $1,000 and skip anyway. So we need to find better ways of dealing with bail. I absolutely agree. Then, Justice Cameron, I'd like to ask if you have any views on the private detention facility. Is it in Makada? If you've been there, if you know anything about that facility, and yeah, and are there any best practices there that we should be looking at that are different to what happens in GCS? Is it better? Is it worse? Does it work? Does it not work? Is there a model that we can consider? I'd like us to engage a little bit on that issue. And then I agree with the points that you've made wholeheartedly, but I would like to add another point that we could perhaps discuss as well is the requirement of sort of professional respect. I see in my interaction with prosecutors, with the legal profession, with members of the South African police, with members of GCS on the occasions when I do oversight there, that there's a marked lack of respect amongst people generally. And, you know, the British police carry no weapons. They're an unarmed force. Yet they're arguably the most respected police force in the world because they're effective. People actually care about when a British policeman addresses them. They're addressed with respect. They're treated, I think, largely with respect. And so the reaction is one of mutual respect. And people actually turn to them for assistance and believe that they will be assisted. In South Africa, the police are treated with no respect. They're disparaged mostly. Nobody expects them to provide any assistance, and largely people don't even bother to report crime. So the crime statistics that we're looking at are so skewed because generally people don't bother to report the crimes because they don't expect the police will do anything. So the nature of the problem is probably 3 times the size of the problem that we think we have. And we need to address that. We need to make our systems effective. We need to make the police effective. We need to make prosecutions effective. We need to make GCS effective so that those institutions carry the respect of South African citizens, so that they want to participate in making them better. And so that people who want to participate in making them better actually want to work there. It shouldn't be a last resort career for anybody. And I don't know how we engender that respect. Our police walk around with massive guns strapped to their hips. And if they, people regard them with, at best, irritation. We need to change that mindset, and we need to talk about ways of doing it so that people want to be policemen because they want to serve the community, that people want to work for DCS because they believe that they can make a contribution to reducing recidivism and turning people out of prison who are better than when they came in, not the opposite, which is what we have now. So I'd like us, if possible, to discuss more fully those aspects before we move on. Thank you. Honorable Maseko Jeli, is that a new hand or an old hand?
It's just a follow-up, Chair.
Sure, go for it.
Thank you very much, Chair. I think one point that maybe I've left earlier, it is the issue of, there was a time, Chair, if you remember, we had a meeting with the OCJ, the Chief Justice. I think with all the problems that we have also when it comes to the issues of sentencing, the issue of training of our lawyers and all that, Chair, I think it has to be also given space, especially this one of training, because one other thing, our magistrates in our courts also must be alive to the situation that we have. Chair, I thought that maybe if also we can consider in future having that meeting. I think we are ready. That time when we met with them, it was for the first time, and some of the issues, we did not really raise them. they're in a manner that now we can maybe raise them. I think so from my side, because if you check the issue of sentencing and issue of bails, yes, that is the issue. It's the issue. It's a constitutional issue matter, particularly on the issues of Bill of Rights. But we also have the issue of Ubuntu, Chair, that is also covered by the Constitution. That also must be also our magistrates and the judges must also look into, Chair, because some of the issues, like Judge Cameron was indicating earlier, they are really small issues that needs also our magistrate and particularly our magistrate at that level, and also the issues of judges in terms of sentencing, long sentences. I do agree that we do have long sentences, but for now, this is what we have. Unless we discuss these issues and look into all the corners, the areas, and then we can be able to say this, in this one, it's a long sentence. The issue of remind prisoners. It is indeed the issue that we need to get into also with the view also of discussing this issue with the office of the OCJ, and maybe we have a workshop before we can even go to other departments. Start talking amongst ourselves about these issues, because we might go outside only to find that the solution is inside. I know that it's a broad issue, as we indicated, but the issue of the Criminal Procedure Act, it is in the House. So before we can even think of saying, let's amend this, that, amend that one, discussions, we need to talk amongst ourselves and find solutions among ourselves. I'll propose, Chair, that we also look into the issue of, before we close this issue that we are about today in this workshop, we might have the very same presentations and the very discussions, but with the Chief Justice and the team, so that we are all alive on these issues. Thank you, Chair.
Thank you, Honourable Mseko Jeli. It's now just after 11. I would suggest that we adjourn until, say, 11:15. Take a short break. Justice Cameron, would that give you and your team time to just consolidate the discussion going forward?
Excellent. Very grateful, Madam Chair. Madam Chair, can I just say a quick thing? I think that what we've heard until now is very, very useful. And I'd like to distinguish between three kinds of problems which this committee has raised. The one is the systemic issues that you and other colleagues have raised, where is disrespect in our country. That's a good example. The second kind of problem is the operational problem. You raise one of those as a good example as well. Judges are indulging, and we have to get a mindset change where this is what happens in the United States, Madam Chair. You start a criminal trial to defend an accused. You stick with that accused. If you haven't got money, you are required nevertheless to see that criminal trial through. You should have thought about your money at the start. We can change the rules of the profession. We can get the Legal Practice Council to do that. We can get judges and appellate judges. The third kind of problem is the structural problem, and we brought a lot of those, which is legislation, departmental regulations like solitary confinement. So if we think of those three kinds of problems, the systemic ones, the structural ones, and the operational ones, we can start honing in on our action plan. And if I may just summarize, Madam Chair, I'm stealing your time. I think that the idea of a larger buy-in is a great idea that your committee members, I think it started with Chairperson Honourable Magwanishe, and it looks as though everyone wants that. Thank you, Madam Chair.
Thank you, Justice Cameron. So can we say we'll be back at 11:15, and that'll give you time to consolidate discussion points? Okay, thank you.
Thank you, Chair.
Thank you, Chair.
in February will be quite quickly. I could speak to the Chief Justice. I know that he shares all of our concerns. He's just given his personal imprimatur to JICS's effort to get individual judges to visit individual prisons. And that's a big step by Chief Justice Zondo and the Constitutional Court. So an early date, Madam Chair, and then we're going to make operational suggestions which we can ask this committee to do today, apart from the important idea of a more inclusive, persuasive dialogue so that we can get rid of our backlog of not discussing this for 22 years. I'm going to ask our CEO, if I may, Madam Chair, to come in here. He's got some responses. He's been to Kutama Sintamule recently, but he's also got other responses if you would indulge him, and then we'll revert with our action plan.
Great, thank you very much. And once again, members, I want to remind us all on the platform that this is in the form of a workshop. It's a dialogue. If somebody raises a point that you would like to discuss further or that you want to make inputs, please feel free to interrupt at any time and do so. You don't need to wait for a speaking turn to do so. Thank you.
CEO, Mr. Mr.
Thank you so much, IJ. Thank you so much, Honorable Chair and Honorable Chairperson, esteemed members of the committee. Yes, I think maybe firstly, just to reflect on some of the discussions that have unfolded during the course of this engagements and presentations by the inspecting judge. Just to cover the issue of Kutama, I was there early this week and on the annual report presentations to the Limpopo province. Yes, absolutely, Honorable Chair. There are many best practices from these, what we would call PPPs. We just need to actually adopt them. And some of them that we can reflect on is how to address the issue of overcrowding. If their number is that is their number and they stick with that. Functional cameras, for an example. And there are many, many other pockets of excellence that comes out of these PPPs, including Mangaung on the other hand. Which we need to consider and adopt into the broader carceral systems operated by DCS. Maybe to reflect further, Madam Chair and esteemed members, the issue of the Chief Justice, as alluded to by the IJ, is that there has been already a set of norms and standards determined by the judiciary. And we just need to reflect on this specifically in relations to criminal matters and civil matters alike. This was actually issued some time ago, I think around about 2016. We just need to get further engagements on this, bring it up to speed and actually redress this. And how do we take this forward with the able assistance, guidance, and leadership of our esteemed Chief Justice? I think that's one area that we could look on and reflect on, Honorable Chairperson. The bail fund, I think there has been, it's only proposals on behalf of the inspecting judge.
I'm sorry, forgive me, but may I interrupt you? I want to engage you on the issue of the PPPs.
Yes.
So you say that the public-private partnerships, there are two of them as far as I'm aware, have pockets of excellence, best practice, but they have a limited lifespan. I know that Mikado is coming to an end relatively soon. I'm not sure how long Mangaung has. What was the time period? 25 years? 20
yes,
years?
I think it's 20 years. I think it's coming to an end around about end of next year. But Mr. D'Souza has those dates, and I think he has more information on them.
Then what's going to happen to them? They revert back to DCS.
Well, on the expiration of that memorandum, I think then it's taken over agreement. It's taken over by the department itself. But Mr. D'Souza has the actual dates. I'm not sure if you would allow him to come in to give us those dates. Now,
okay, let's say that it happens in a year or two. That's fine. But what is going to happen to those facilities then? What is going to happen to their pockets of excellence and their best practice then? Are they going to remain and retain? And are they going to drag the rest of DC up to their standard? Or is DCS going to just dilute all of that into their already dysfunctional system and drag them down to the same human rights abuses that we now see in our prisons.
Yes,
do you have any view on that?
I think that's the
I
most
know
appropriate.
it's a question that we should be asking DCS as well, but I'd like your view on it from JICS's point of view.
Yeah, well, most importantly, Honorable Chair, I think we would be guided by this committee of how that integration takes place going forward. And obviously, how do we merge what we would call a PPP into the integrated system of corrections of the department. I'm not sure how the way forward is going to be unpacked, but I guess the National Commissioner, together with leadership of DCS, will be in a better space to respond to this. But nevertheless, let me allow Mr. D'Souza
Hold
to
on a
give
moment, please. Honorable Msekajeli also wants to make a contribution.
Most welcome, Honorable Chair.
Thank you very much, Chair. I think what you have covered me on the part of asking what's going to happen to those PPP, but also I think there was a time in the committee where we discussed this issue of handover and the ending of a term of these contracts. But I thought that maybe the department, I'm not sure if they are here, Chairperson. They were supposed to, yeah, because we're gonna have a serious problem. Because also I would think, because in the when we were discussing this issue earlier, it was the issue of capacity in terms of, are they going to be able to continue to all like those pockets of excellence that exist within those and also the capacity in terms of human resource. Are they ready? But it was like there was a time where, I might be mistaken, Chair, where they were trying to tell us that there is that move in terms of working towards that. But I think you are correct, Chair. If we can have a report on that area exactly, because if you're saying it's 2 years now, less than 1 year, maybe, as we are sitting here, and we don't have a report in that regard, it can also be a problem, only to find that when this thing, the contract ends, we find ourselves here again. I think it is important, it's as a matter of urgent, Chair, we need to look into that matter. Thank you, Chair.
Thank you, Honorable Mr. Sorry, I interrupted you. Please proceed.
No, not at all, Madam Chair. It is an active, interactive discussions. And yes, I was just welcoming Mr. D'Souza to give us the actual dates of those contracts. Maybe he'll be in a better space to give us that. But yes, further engagements with the department, the minister himself, and I'm sure all other relevant role players, specifically in relations to our partnerships or those PPPs, should unfold very soon. He says the contracts were for 25 years. The end of the contract is in 2025. Mangaung will end in 2027. Will end in 2026. Yeah, it's there in the email chat box.
Thank you. Honorable Niva Drachen, there's no need to raise your hand. Please just speak when you want to speak. Interrupt and speak. Thank you.
Sorry, Chair, the interpreter is just muted. Just one question to ask: if JICS is in consultation with the Department of Correctional Services, talking about it, so that they not only talk about it when there's a handover, but if it can start now. I just wanted to know if that's the case.
Thank you, Honorable Niva.
Yes, no, thank you, Honorable Chair and Honorable Nivot, for that question. Yes, I'm sure we'll be led by the inspecting judge. We have not opened discussions on those subjects as yet, on the takeover or the merging of those PPPs into the DCS environment. But I'm sure as we move forward, we can place this on our agenda, on our quarterly meetings that we meet the National Commissioner and his executive management. And we can initiate the discussions around the integration of those two PPEs into DCS and what has been done, and then obviously come back to this esteemed committee and inform this esteemed committee on progress being made with regards to that discussions.
Thank you. You were
Madam
going to
Chair.
raise other points. Go ahead. Who wants to speak?
Judge.
Madam Chair,
sorry.
may I just make a brief point supplementing my CEO's? My approach to the public-private partnerships of prisons is quite a skeptical one. There's been a long and grievous debate in the United States about this, where much more pernicious things have come out in private prisons than we have in South Africa, because we have fewer and they're much more scrutinized. But my own approach is that the end of these contracts will, in general, but also more specifically, be a good thing. We can, as the CEO rightly suggests, pick up good practices from those operational issues of the private prisons. But I think it's a good thing that it comes back. The incarceration of offenders is a public duty that should be entrusted to the state, and not in a public-private partnership to prisons. That's in principle, but also in practice, Madam Chair. I think there are grave difficulties. We could go into them now. We were at Mango and Max just last year, and there really are difficulties in coordinating issues. There are payment difficulties. They've got to keep the prison full in order to be able to pay. That means that you can't be scaled from max to medium until there's someone to take your place. I could go on. I'm not going to go on, Madam Chair, just to introduce that slightly different perspective.
Thank you very much, Justice Kenner. Mr. Mercer, you had other points you wanted to raise. Go ahead.
Well, thank you so much, Honourable Chair and Honourable Members, Judge. Yes, I was on the point on considering establishing a bail fund in the South African context, specifically in relation to those that cannot afford bail under 1,000 Rand. So, yes, as ably led by our inspecting judge, he's already dispatched what we'd call a letter to the minister. We've had roundtable discussions where the IJ has already briefed the minister of proposals of considering a bail fund to be established in South Africa. And obviously that would be a consortium that would deal with it outside the domains of JICS and has nothing to do with JICS specifically. I think it is something that it is innovative, and it's trying to address specifically the relations of the remand detainees, as the sums were already given to you in the presentations, sitting at almost 51,000 out of the incarcerated numbers of 150,000. So I think that's the crux of the establishment or consideration of establishing a bail fund. I'm not sure, IJ, if you want to add any further on that.
Thank you very much, CEO. Just to say that all of this will be generated outside the existing governmental and state system by private funders, contributors, donors. It will not be profit directed. There's going to be no profit interest. So we are seeking public benefit funding for it. We do have a memorandum, which I think we should go back and share, not just with the minister and within JICS, but it's a group of private benefactors, the Bertha Foundation, the Bertha Institute at the University of Cape Town, Mr. Robbie Brosen, whom the committee may know as the founder or co-founder of Nando's, Rabbi Michael Katz. So it is parallel. It won't cost the state anything. It won't interfere with the state. Madam Chair, you've made the point that there's a misunderstanding about bail. When you've been granted bail, it means the magistrate knows that you're not going to tinker with state witnesses. You've got an address. You're not going to run away. You will stand your trial. So as you've said, Madam Chair, those people should not be in jail once they've been given bail. And it's a malfunction of the system that we hope to address from the outside. But I do think the CEO and you have made a good point that we should inform this committee much more of where we are and where we hope to get. Thank you.
Chairperson.
Go ahead.
Yes, on the very same issue of that fund, Chair, I think we must also make a follow up, because this issue you're funded by private people, and this is a state owned institution. And remember, there were concerns about the funds for the NPA to be funded by private people, because there is a sensitivity that comes with it. You know, when on these issues of law and justice, we have to be very careful, because we want the true independent on this institution, so that we don't have, it might be Justice Cameroon now, but tomorrow it can be somebody else. These institutions, we have to treat them with careful or care, because they can turn out to be something else. So we must also, Judge Cameroon, we must also look in that area. Thank you, Chair.
Thank you, Honourable Masekajile. Yes, I agree with you that any fund should be very carefully administered. But as I understand a bail fund, and perhaps Justice Cameron can explain a little bit more about the nature of a bail fund. But as I understand a bail fund, it's a private collection of money on often charitable donations used to pay bail for people who can't afford to pay bail, and the fund itself will assess the risk involved and pay the bail for a person who can't afford it. So it's not it doesn't affect any state-owned institution as I see it. It's a sort of a contract between the accused person and the people putting up his bail. If he skips his trial, their money is at risk. And if he attends his trial, they'll get their money back.
Madam Chair,
it doesn't affect any state institution as far as I can see. Yeah.
Just to add, Madam Chair, that your members, honourable members' concern is, I think, absolutely justified. It is correct, as you've said, that it's external to the state. It's not quite the same as the analogy your honourable member draws of funding the NPA, because the NPA is a state institution. Here you're funding a private individual who is within a state institution in the correctional system, but can't afford the bail which he or she is entitled to. Nevertheless, your member makes the good point that we should keep strong tabs on this. And that's why I think we should bring our MIMO at this stage. We've raised funds for what is it called? A scope, an operational scope, a project scope, where you find out whether something's going to work or not. That's what we've raised funds for. And I think that MIMO, which we very carefully put together, should be made available to your members so that they can understand it better. And I think that the idea of caution in relation to this is well warranted, and we will certainly go along with that. Thank you to your member.
Thank you, Justice Cameron, and thank you, Honourable Masekajile, for that input. Mr. Missa, you want to continue?
Yes, thank you so much, Madam Chair. I think we'd make that memo available, and the letters that we've submitted to our Honourable Minister for our esteemed committee for further reflection and engagement on this. I just want to cover the aspect, Madam Chair, on the issue of non-nationals. Yesterday, I was at Barberton management area, and at that area, what came through very strongly was the deportation orders that is normally released by the Department of Home Affairs on what we would call non-nationals that needs to be deported back to the countries of origin. That is not coming through very strongly. And therefore, we've, in the presentation on this workshop, indicated engagements with the Department of Home Affairs of taking this forward and taking this discussion forward of how do we address the deportation orders, specifically in relations to some of those inmates where their term of sentence has already expired and that they still remain in custody. So I think that's the aspect on the non-nationals I'd like to reflect on and comment. Maybe the last one from me is, Madam Chair, if you'd allow me, is this is just not a one-stop shop. We need to go back. We need to put all hands on deck. We need to ensure that all role players are on board. We need to ensure that specifically addressing the entire prison reform, or what you would call the incarceral systems in South Africa, we need to get everyone involved. And if we go back to the terms and references of this workshop as crafted, it has actually indicated various stakeholders and role players' participation, and the intended future meetings as proposed by our inspecting judge sometime early in February next year. We should then try and see if we could engage all of them to be on board so that we could take our discussion further. Thank you for the opportunity, Judge.
Just want to get a list. May I, Madam Chair, subject to you and your members' direction, may I suggest that where we are now, where JICS's wish list is, and we're distinguishing between structural issues, which, as your Honourable Member Maseko Jele said, will require further reflection, further consultation, further bringing people in. First of all, let us agree on a broad workshop which will bring in criminal justice stakeholders and Chief Justice Zondo or his delegate from the Constitutional Court. We ask you, nevertheless, on an immediate basis, Madam Chair, we ask this committee to call upon DCS to operationalize immediately its Section 63A powers to decongest. We know, Madam Chair, and can I just say, one of your members rightly said, this is not the fault of DCS officials. I've never blamed DCS officials. There are some who are corrupt. Most of them are doing a horrible job that we've required them to do. I think it was Mr. Engelbrecht who made that point. We've never blamed DCS. We require them to do this terrible task of overcrowded prisons, of insufficient facilities, of decaying infrastructure. So our respect and sympathy is with them, but here is something that they can do. Third, we think this committee should endorse, Madam Chair, I can't emphasize it enough. There's a prosecutor whom you know from the early 1960s, Mr. J.J. du Toit SC, who was mandated by President Mandela to join the prosecution team in The Hague in the International Court of Justice. And he and I wrote an article together recently in the De Rebus, which made the point that you've made, Madam Chair. Judges and judicial officers have to get themselves in line as well. They've got to say, no, you will not get another postponement. You've been careful to skirt around current controversies. I will do the same. This committee knows that I never court controversy. The antics of defense lawyers should be firmly dealt with by presiding officers in whatever forum. So we suggest that the committee endorse the suggestion that lawyers, prosecutors, and judges should be able to should find practical ways of addressing successive, unnecessary, unjustified, unwarranted delays in the criminal process. And then a fourth, Madam Chair, we suggest that maybe you and the Honourable Chair of the committee, Honourable Mr. Bululani Magwanishe, could maybe deputize someone to work with me and Mr. Missa on the bail fund for indigent remandees, someone that we can keep in touch with, someone that we can give our project plan to. We're still at a nascent stage of a feasibility study. That was the term I couldn't. We're still at feasibility study stage. We've got money to do a feasibility study, and that's where we are. So that's the fourth thing, Madam Chair. And then, Madam Chair, really, I can't let the committee off the hook in two respects with structural issues. The one is sex work. I think it's gone through cabinet. Deputy Minister JJ Jeffrey will be able to inform the committee. That should have been decrimmed many years ago. This is not a question of morality. It's a question of the application of the criminal law, very similar to what this committee rightfully and path-breakingly did on sexual orientation 25 years ago. Yes, we differ on homosexuality. I'm a proudly gay man. There might be members of the committee to whom sexual orientation are strange issues. But the committee decided that this is not the purview of the criminal law. Exactly the same argument applies to those women, and they're mostly vulnerable women who are caring for their children, their parents, their relatives in rural areas through sex work. We must distinguish the morality of that from the terrible consequences of prosecution, intimidation, blackmail from the criminal law. The second respect in which I don't want to let the committee off the hook, with great respect, Madam Chair, is petty offences. There's a list that can be decriminalised. And then the President Kgalema Motlanthe issue. I would beg this committee to form a subcommittee or with JICS to form a working group, a small working group of a handful of us on drugs. The Cape Flats, Madam Chair, one last figure for this morning together is that the murder rate is distorted in South Africa by the fact that in Khayelitsha and the Cape Flats, it is higher than in Central and South America. Our national murder rate has risen to 40 per 100,000. To give the committee an idea of how high our murder rate is, that is 6 times the world average. The world average murder rate is 7 per 100,000. We are now right up there with some Central and South American countries. But worse still, double that, Khayelitsha over 100 per 100,000. So there's a crisis of murder in the Cape Town townships and Cape Flats. And in my very respectful submission, that is fueled by the fact that drugs are syndicates. And then finally, again, the question, we will come back to the committee, number 6, on private prisons. Madam Chair, we delivered a raw, but I think it's a step forward. If the committee accepts that we just need to recalibrate, we cannot fix crime intelligence now. We cannot abolish everything. We cannot start everything, but let's start in these modest, mousy-wousy ways, and let's recalibrate, and we will proceed from next year's broader, inclusive working seminar. Thank you very much, Madam Chair, and thank you to your members for letting me make these suggestions. May I ask, with your indulgence, Madam Chair, colleagues, CEO Missa, Tembi, Zodwa, Leonard, anyone else who wants to make suggestions? We have the ear of the committee for now.
Chair, before that, I just wanted to find out if maybe the list that Judge Cameron is now giving us, can we also maybe be sent to us so that we can look into it? Thank you.
We will do so within 20 minutes. Madam, sorry for interrupting. Within 20 minutes of the end of, thank you, ma'am.
Honourable Niva Drache.
Thank you, Chair. Thank you, Madam Chair. Thank you, Justice Cameron. I see what is not added here, and maybe it's because it's a very minor thing, but I do feel it is important to mention as well. As the Deputy Minister Holomisa previously brought before the committee, the number of state patients in correctional centres, because of not having enough bed space in the health facilities for mentally ill patients. And I think we need to understand that mental health, the mental health situation of inmates is also more. And the reason why I'm saying this is because I think I recently read, a few weeks ago, I read an article where the mentally ill man, he had a mental episode and he didn't pay for his meal at the restaurant, and immediately he got arrested and he was kept for a few days. But the father struggled to get him out of jail, and our prisons are so overcrowded, but we're willing to, you know, jail people who are, for example, have mental health issues and who really actually just need treatment as a mentally ill patient. So I think the state patients who are in correctional centers should also be looked at, because I think it also adds to the overcrowding instances. Thanks, Chair.
Madam Chair, may I make a comment, please?
Please go ahead. Thank you, Honourable Nived.
Thank you. That's our bad. It should have been on our
Justice,
list.
can the Secretariat please unpin Honourable Neodruchen? Thanks.
It's our bad. I'm very grateful to the Honourable Neodruchen for raising that. It's a particular concern of our CEO, Mr. Misser. He, since I became inspecting judge nearly 3 years ago, he repeatedly raises this. Mr. Misser, please won't you reiterate my apology that we didn't add it to our list this morning. It was our fault.
No, absolutely, Judge. But if we're releasing our second quarter report very soon, Honourable Chair, Madam Chair, soon. But as I speak to you now, we have 117 declared state patients already still in our places of confinement and incarcerated in our correctional services across the country. The greatest challenge is the central management region, or what we would call the Bloemfontein or the Free State and the Northern Cape region, coupled with certain other areas that brings up the total to 117. But what we have done, and maybe that's of interest to the committee, through the signature of the inspecting judge, who has already penned a letter to the Minister of Health to intervene and to get his audience on the subject, ceasing those letters to all MECs of those respective regions or provinces of the MECs of Health to also assist. But broadly, Madam Chair, Chairperson and honourable members, the problem is the institutions itself that houses and accommodates state patients. I think that's one area. There has been some engagements with the Barberton management area because they don't have institutions in the Mpumalanga region. They have now signed up an agreement through the National Commissioner with Serfontein, I think it's here in Pretoria, to accommodate some of their declared state patients, to assist and relieve them of the problem. But beyond this, Madam Chair, Chairperson, honourable members, it's not just only the declared state patients that we're having a problem with in our places of confinement. We are having serious problems with those other inmates that have some form of psychotic behavior or some form of psychosis that is actually burdening and straining the incarceral system, and also the safe custody of these specific individuals, coupled with also officials that need to ensure their safe custody and other inmates. So this is another area that we need to also look at, Madam Chair, Chairperson, and honourable members. Apart from the declared state patients, we need to also look at how we can treat these inmates that have some form of psychosis. Thank you, IJ.
Thank you very much, Mr. Misser. Justice Cameron, is there anybody else on the platform from Honourable Magwanishe?
Yes, I would like to propose that we consider the first week of March, or in March, because February is a very busy month with the State of the Nation towards the end of the month and budgets. So I would propose that immediately thereafter, after the budget, maybe we can consider having this bigger workshop, and then also that after we have received the list that Judge has promised us, that it is presented for consideration by the committee so that it can be part of the parliamentary process. Thank you, Chair.
Thank you very much for that, Honourable Magwanishe. You'll know the program planning possibilities much better than any of us. So thank you very much for that suggestion. Justice Cameron, is there anybody else from JICS who wants to make an input?
Tembi, Zodwa, Leonard, Emerentia. I don't think anyone is volunteering at the moment. I don't want to put them on the line. But may I suggest, in the light of the Honourable Mr. Bulelani Magwanishe's intervention, that we provisionally think of Friday the 10th of March?
Yeah, we can consider that date.
And then we will send our action list. I maybe have been a bit ambitious to say within 20 minutes, but within an hour or two, ma'am.
There's not that type of rush. If we get it soon, that's fine. Yeah. Is there anybody else on the platform who'd like to make an input?
And I didn't mention Ms. Mukari Belapi. Belapi, if you have anything to input, most welcome.
No input from me. Thank you.
Honourable Niva Drachen.
I was trying to type faster, but I typed too slow. I just wanted one more thing. Those who are put in solitary confinement, maybe now, but placed in solitary confinement, how many of them actually have mental illnesses or had a mental episode at that moment and was placed in solitary confinement, because of that. But those statistics you can provide at a later stage. Thanks. Anpan, please.
May I say, Madam Chair, with your permission, that's a beautiful question. And Ms. Sabuta, our regional executive, has initiated a study of the effects on the people. It's a slightly different point, the effects of solitary confinement on people, mental and physical health, because we believe they are adverse. And she, of her initiative, is working with DCS right now to do a survey of effects at Ebongweni, which is in Kokstad. Thank you very much for that input.
Thank you very much to both JICS and Honourable Niva Drachen. Honourable Maseko Jele.
I think this is the last one for me. I just want to find out, I didn't hear from the presentation, in addition to what Honourable Niva Drachen was talking about, the issue of women and children in those prisons, the challenges that they might have been facing that maybe have been presented to JICS. I didn't get that one, Chair.
We thank you very much, ma'am. We do have it through you, Madam Chair. We do have it on one slide. I think I was going too fast at that point, but we are worried about the provision of female hygiene products to people in prison. We are dealing now at operational level, ma'am, with the issue of whether a female inmate who enters incarceration pregnant, whether she gets quick enough access to an abortion if she wants it, because it seemed to us that the present practice of DCS is that she needs to get the permission of the head of center first. And that doesn't appear anywhere in that wonderful statute which Health Minister Nkosazana Dlamini Zuma in 1996 enacted, the Termination of Pregnancy Act. So there are issues that we at JICS are very, very much concerned about and in touch with about mothers and children and gender-specific women issues in prison. Thank you for raising that.
Thank you, Justice Cameron. Is there anything else that anybody else on the platform wants to raise before we wrap? We did have the whole day, but if we're going to finish early, that's fine. But there's certainly time for anybody to raise any issues they may want to raise.
Madam Chair, if you ask a lawyer, I can repeat everything I said for the next 4 hours.
Please don't. Please don't. Fortunately, it's all recorded. So, okay. So then, in wrapping up, thank you to JICS for their efforts in putting this together, for raising these points and for crystallizing them in a fashion that are in bite-sized chunks so that we can digest them quite easily. I think that I certainly, and I'm sure I speak for all the members, have benefited enormously from this process. I have a much better grasp of what the major issues are going forward than I had earlier today. I agree that the revitalization, re-establishment, redirection of crime intelligence across the entire spectrum. Sorry, just one moment. There's somebody shouting at my door. Just excuse me 1 second. I apologize profusely. I have an over-enthusiastic neighbor who shouts at my window and then my dogs go berserk. Crime intelligence is vital for all of these aspects, but in the criminal justice system, certainly it is seriously lacking, and we do need to give it attention. We do need better administrative and administrative systems and better planning in the department, and we constantly are missing deadlines, and that does need to be attended to. So those are issues that we do need to address. The fact that there is no synergy across the departments in the criminal justice system is a matter of ongoing concern, I think, to all members of this committee. It's pointless trying to address any of these issues in a silo fashion. If we don't fix from the beginning to the end of it, there's no point in trying to fix anything. So the silo approach is not going to work. There must be a synergy approach. I think that a more comprehensive workshop is going to be of great value, a great benefit, as long as the outcome of that workshop are serious action steps that are then implemented. Talking is wonderful. It leads to great understanding, but if there's no implementation, we may as well not have bothered. This committee has a limited lifespan. We work exceptionally well together, and I would really like to see us achieve the implementation of some of these issues before the end of this parliament. We have in the Honourable Magwanishe an outstanding chairperson who drives issues in this committee exceptionally well, and I think we're all supporting 100% in trying to achieve implementation of these issues. So an expanded workshop would be great. We could work on the date suggested, and we'll support the chair in any way we can. But there will have to be a variety of departments: the police, the DCS, the NPA, Home Affairs, probably Public Works. They're responsible for most of the human rights problems, in my view, in prisons. The fact that our prisons look like they look is a source of constant embarrassment and concern to me. And some of our maximum security prisons are an absolute disgrace. My personal bugbear is St. Albans, and I say it all the time: if the people who are in there had been animals, I would not have left them there. And certainly people should not be incarcerated in that fashion. incarceration should be your punishment, not prison. Not the way the prison is. That should not be your punishment. Then we also, I think, need to concentrate a little bit on continuity. Once we've discussed these issues, once we've crystallized the problems, once we've developed a plan to implement solutions, we must implement them. And so we need to do that. So unless anybody's got anything to add, I think those are the key points that we should take out of this. I absolutely agree with the yes, Honourable Secretary.
Before you close it, I want to find out which one comes first. The one with the OCJ and the broader one with everybody. I'll tell you why. I think why I proposed that one. There is a statement that the Minister of Police said not long that their duty is to arrest people. He was addressing a community, and he said, no, we don't know what is happening at the courts. So the courts are releasing people, they are arresting people. So hence I thought that it would be better for us to start with that one of the courts before we can even go, because we are going to have those like responses with the police once we meet with them. Thank you, Chair.
Thank you, Honourable Secretary. Yes, we will have to, as a committee, I suppose, decide on our program and see how we will structure our engagements prior to the broader workshop. That would be a sensible approach to achieving some sort of synergy in the broader workshop. And I'm sure that Honourable Magwanisha will lead us in that discussion. But it's a point well made, and thank you. May I just say that the Minister of Police is not incorrect. It is the police's job to arrest people, although it's not the police's job to arrest people without proper forethought. And it's absolutely pointless arresting people and dumping them on the doorstep of the court with no reasonable or admissible evidence to back it up. Then the prosecution has no choice but to not enroll that matter. And if they do enroll it, then the court has no choice but to strike it off. So it may be their job to arrest people, but they need to do their job thoroughly and efficiently, and then that problem won't arise. And those are one of the issues that we will have to address, is how we deal with the police. The NPA is only as good as what the police bring them. The judiciary is only as good as what the NPA presents to them. So it can't be a blame game. They feed into each other, and they are interdependent, and it can't be avoided. DCS has to deal with that which the judiciary sends them. It must be, there's synergy across all of those facets, and we need to explore that synergy and find a way of making it more efficient and more effective and more humane and fair. So I then thank everybody for their participation today. I've personally found it very helpful, and I hope everybody else has. It's clear that JICS has worked very hard, both in the presentation of this workshop, but also in getting that office running in an effective fashion that actually grapples with the issues that JICS is meant to grapple with, which are many. And clearly they're concentrating their minds on issues that are important, and it's our business as the committee to assist them in every way that we can to do their job as effectively as possible. So I thank everybody for their presence and their participation today, and I would invite Honourable Magwanisha to make some final comments. Thank you.
No, thank you very much, Chair. Madam Chair, thank you very much for chairing this meeting in an exceptionally good way. Thanks to the judge and to the members of JICS, members of the portfolio committee. I think the way we are working together, we are putting into action the words of Nelson Mandela when he said, "In every nation there are good men and women." And I can say that you represent those that are very good in our society, despite our different political persuasions, but we can all be united for the betterment of our country. Thank you very much, Judge, for always being there, for always being humble, intellectually robust. We think that this effort, with your assistance and on our side, Honorable Breitenbach, Honorable Janji, when he's done with Section 194, we'll be able to take these processes forward. And we were generally talking amongst ourselves that some of the issues you have raised, we have been raising them, and we would even at some point would want them to make them part of our study tour. We have raised the issue of sex work, we have raised the issue of drug, and the issue of poverty, prisoners of poverty, which is a very serious issue. Thank you very much. I do think that Honorable Breitenbach is correct that we have really gained a lot this morning. Thank you very much, Honorable Breitenbach, for chairing and for leading us, and even with the logistics. Thank you very much.
Our thanks to everyone as well, Madam Chair and Chair Magwanishe. Thank you.
Okay, so thank you very much then, everybody. Thank you to the committee secretariat for their hard work also in liaising with JICS and putting this together.
Yes.
I'm very grateful, and in his absence, thank you to Honorable Janki for his inputs. If there's nothing else, then the meeting can adjourn. Thank you very much.
Long live the chair.
Thank you. Long live.